What are the 6 steps I need to take when I'm creating an estate plan? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to take a quick look at 6 steps you can take when creating your estate plan. So while your estate plan should be unique and tailored directly to you and your legacy, there are some common steps that everyone takes when they're creating an estate plan. And this is especially true when you're working with a professional like an attorney, and you're working with your financial advisor and your accountant. If you're working with just a website where you're going to be clicking some boxes and filling in some information, these steps are very important. But you have to be careful because sometimes you click the wrong box or you get the wrong document, and even though you have the best of intentions of creating that estate plan, you might end up with documents that aren't doing what you actually want them to be doing. Step number 1 in the process, let's create a catalog of your assets. So we want to go through and see what kind of assets you own and how we own them. So for example, if you have an asset like a retirement account that has a beneficiary designation, that is treated differently in your estate plan than your checking account that you use on a day-to-day basis. Those retirement accounts, we can use beneficiary designations so that that asset does not need to pass under your estate plan. However, if you're setting up a trust and you have children under the age of 18, you may actually have that trust end up being the beneficiary. But this is where it's important that we know all of the different assets that would be in your estate so we can figure out how to properly distribute them. And also, depending upon the amount of money in these various assets, we have to make sure we're not running into any kind of an estate tax problem. So remember, on the federal level, there's an estate tax, and depending upon what state you live in, there can either be an estate tax or an inheritance tax, which an inheritance tax is applied to the people receiving the property. The estate tax is applied against the value of your estate. Step number 2, let's determine the future family needs. So let's look at our children, let's look at our family members, let's look at the people who are going to be inheriting under your estate and make sure we know who needs what. So many clients will want to have an equal distribution. Let's say they have 4 kids and the default for them is let's just give a quarter to each of the children and we'll be all set. However, when you look at those 4 children, you may find that one has special needs and we can't give them a straight inheritance. The next one maybe works on Wall Street and has more money than everybody else in the family combined. Maybe the third has been out of work for a while and the fourth is working a good job and is living a nice life with their family. Each of the needs for those 4 children is different, so we don't necessarily want to divide them up 1/4 each. We may want to skew it a bit, and in the case of the child with special needs, we may need to create a special kind of trust, a special needs trust, so that their inheritance does not disqualify them from their government benefits. Step number 3, we want to assign our beneficiaries. So as we talked about back in step number 1, when we're creating all of our assets and we're creating that catalog and that list, we want to also make sure we know what assets have a beneficiary designation. The reason is, again, this passes outside of your probate estate, so it doesn't have to go through the court process. It can go directly to a beneficiary. Now, if you don't choose a beneficiary, or if you leave your beneficiary as a default of my estate, then what happens is all that money then goes into your estate and may cause probate problems. Now, this is most common in the area of life insurance. Let's say you have a $5 million policy, or let's say it's a $10 million policy, and you live in a state with an estate tax. If that $10 million is not given by beneficiary, but instead goes into your estate to be distributed, you can run into significant estate tax problems that you weren't planning on. So where we have beneficiaries that are able to be designated, we want to make sure we're using them. It's a great tool to help with your estate plan. Step number 4, let's plan that distribution. Again, we've looked at a variety of different assets, some which will be distributed by beneficiary designation, others that have to go through your estate. And what we want to do is create the plan for how everything will be distributed. Going back to our example of the 4 children, if we have a child with special needs, we want to make sure that there's a proper distribution plan to protect their government benefits. Maybe that child that's on Wall Street that has more money than everyone combined is fine with not receiving an inheritance. We just have to make sure that's properly laid out in your estate plan. If you go to some website and check the boxes, they're going to just automatically distribute equally to the 4 children. And as we've been talking about in that situation, that may not be what you want to do. Step number 5, let's secure and share your documents. So first of all, you want to make sure you know where the originals are. We're not going to put the original documents in a safe deposit box. I've given you other videos on this topic, and it's one of those common misconceptions. While a safe deposit box can be very safe, the problem is when you die, you can't open that safe deposit box without a court order. So if you've created an estate plan to allow for informal probate in the state where you're located, you've now created the need for a switch into a formal probate to get a court order to be able to open that safe deposit box. You also want to look at sharing the documents with the right people. So when we have things like powers of attorney, and what they do is say when you are still alive, if there's an issue where you want somebody else to take over your finances or to be making healthcare decisions for you, we need to make sure that the people who are named as the attorneys in fact or the agents in those documents, first of all, know where the documents are and know how to locate them and get them to the appropriate people. So we need to make sure we have this as part of our plan. And when you work in my office, we also give you a checklist at the time you sign your documents where we lay out all the different documents, where they're located, who the important members of your team are, your attorney, your insurance agent, your accountant, your financial advisor. We want all of that information easily at the fingertips of whoever's going to be monitoring and administering your estate so that they don't have to go digging and search all over for this information. And step number 6, of course, update your plan regularly. So if you work with an attorney, they're going to get back in touch with you every couple of years and just check in. So maybe there's no need for an update in 2 or 3 years. Maybe nothing's really changed. You should still at least be having that contact point with your attorney and making sure that if there is something that's changed, maybe one of your administrators has died, maybe a trustee has moved away and would no longer be the right pick for you to manage money for your children. There can be a variety of reasons, but we want to make sure that we're updating our plan regularly if we need to. And a lot of times you don't need to. Many times when I have calls with my clients after that 3-year period and say, let's just check in and see where we are, we work it out and say, you know what, we don't need to make any changes. We're good. We'll see you again in 3 years. We'll check back in and see, is there anything else that needs to change? The final step, not part of the 6, but just a heavy recommendation I'm giving to you, and that's going to be working with an attorney. Work with an attorney on your estate plan, not just because I'm an attorney telling you to, but because the professionals can help you make sure it's done correctly. We can get you the right documents that you actually need, not just checking some boxes on a website and hoping you chose the right options for you and your family. You really don't want to have the wrong documents, appointing the wrong people, because you can leave a terrible mess for your family. I can't tell you how many times I have clients bring me documents they downloaded online, they filled out, maybe they signed incorrectly, or it has provisions they didn't know they were signing. So work with a professional. It's worth that time to go through it with a professional and make sure you're getting the right documents for you and your family. If you're ready to get started or if you have more questions, you can go to my website, 𝙃𝙀𝙍𝙀𝙀. There's a red legal strategy session button on the front page. If you click it, you'll be taken to a page with my personal calendar. We can set up a legal strategy session. It's a 15 or 20-minute phone call where we can talk about where you are in the estate planning process, whether we're starting a new estate plan or whether we're updating an old one. Let's make sure we've got your documents updated and ready for you and your family. If you like this video, you can hit the like or the thumbs up button below. You can share it, and you can always hop to ayerslaw.tv.com or youtube.com and subscribe to the channel for future episodes.